Hello everyone. I have been making a few videos about the new points-based system in UK, skilled worker visa. Made about 4 or 5 videos where I've explained about the points-based system in detail, about how you can get the points-based system, how you can switch to points-based system if you're in UK, and basically all of the rules in 4 or 5 different videos. But still, there are a lot of people asking new questions in emails. I'm trying to reply to as many emails as possible. I'm not a professional immigration advisor, but I'm providing it as a clarification as per my understanding. So, they are all basically the Home Office rules that I'm just pointing out to. But, the last few days or few weeks, there have been so many emails with probably some of the repeated questions. And I try to answer as much as possible, but even like 10 or 15 emails take too much time. Even if I spend 5-10 minutes for each email, it takes more than an hour on a daily basis. I'm not able to reply to everyone. So what I thought was I'll consolidate all of the questions that are being asked and prepare another content, and also just recap all of the content that we have said as like one consolidated video, and especially about the cost, about switching within UK, about if you're already with another employer in ICT, how you can easily go to a points-based system. All of the things that we have talked about, probably in a very simple and consolidated manner today. So let's get into the video. So let's start with the basics first. So prepare the content, but let's start with the basics. First thing is, I'm not an immigration advisor, I'm not an immigration expert, like I've already said, and none of this content is immigration advice or legal advice. What I'm doing is basically I'm just providing clarity and information based on my own interpretation of the Home Office information and my understanding of the Home Office information, simplifying it for people who don't have the time or who cannot find all that information spread across all of the Home Office document. And so you make your own decisions based on your own research. Take this with a pinch of salt as an understanding and as an interpretation. This is not legal advice or immigration advice. If you want to consult with the Home Office, do it. They have their phone numbers. You can call them up if you still have confirmation. Or in your case, if you really need, you can go for an immigration advice as well. This is not an immigration advice. I'm just wanting to clarify it as a disclaimer. Now, what are the key changes with skilled worker visa? So previously, till December 2020, we had something called as a Tier 2 general visa. The new points-based system replaced the Tier 2 general visa, and it is currently live from December 2020 onwards. 1st December 2020, we even published a video when it went live with a lot of information. That's the date that it went live. So earlier, Tier 2 ICT holders in UK were not allowed to switch to the Tier 2 general without a 12-month cooling off period. So they needed to go back to India, be there in India for 12 months. Only then the Tier 2 ICT visa holders, intra-company transfer, if you had come from an Indian company, then only then you can actually switch to this Tier 2 general visa. Now you can switch to the skilled worker visa within the UK itself. There is no cooling off period. Also in Tier 2 ICT, you cannot get ILR, which is one of the reasons people wanted to switch to Tier 2 general. So in this new skilled worker visa, you will get your ILR if you stay in that skilled worker visa for 5 years and satisfy all the other criteria for the ILR, indefinite leave to remain, which is permanent residency in UK. So that is one of the reasons why people would want to actually switch to the skilled worker visa. And like we already said, previous years from your ICT don't count. But if you stayed in Tier 2 general and switching to skilled worker visa, that counts from a 5-year count perspective. And the main point that has been removed is there is no resident labor market test, meaning a company does not have to prove that they were not able to find anybody in UK for that particular job, and only because they are not able to find someone, they are sponsoring someone in Tier 2 general, which was very difficult in Tier 2 general, and that's been removed, which means that a company has a legitimate requirement to find someone, they can actually bring someone. There is no other proof that needs to be submitted. What does it mean for the employers, actually, people who want to actually sponsor a company? So the process has been made really simple for employers who actually want to sponsor people. So especially removal of those two factors is a big boon. But on top of that, the overall process is really simple. First thing is they need to apply for a sponsorship license. A sponsorship license is the first step if a UK employer want to actually sponsor someone in UK. That's a one license per company. You get a sponsorship license, you become an eligible sponsor. You do not need to demonstrate that you are not able to find a suitable resource only because of that you want to sponsor someone. You want to become a sponsor, you can actually apply and get a sponsorship license. It's as simple as that. As long as your resource that you want to hire meets the 70 points English knowledge requirement academic qualifications, and the job is in a approved skill level of RQF level 3 and above. For example, there are skill-less jobs, or rather low-skilled jobs that do not qualify. That probably would be a bit difficult. But if you're hiring someone at an RQF level 3, which is again lowered from the tier 2 general, so a lot of jobs have actually come into most of the jobs have actually come into this picture as well. So you can sponsor for it. Every employee that you want to sponsor, you need to get one certificate of sponsorship. So if you intend to sponsor somebody, like 5 people, if you intend to sponsor, you need to get 5 certificate of sponsorships. If you intend to sponsor only one person, you get only 1 certificate of sponsorship. To bring somebody from India, you need a defined certificate, basically outside of the UK. To sponsor someone within the UK, you need an undefined certificate. So earlier they used to call this as restricted and unrestricted certificate in tier 2 general. The name has just been changed to defined and undefined certificate. Pretty much it's just the category of certificate that you need to get, so that you don't interchange and use these certificates. So they know that you're hiring within UK or hiring from India, and that's basically an application process. When you apply, you say, I intend to bring somebody from India or somebody from outside, from the UK, and then they give you either a defined or an undefined based on your requirement. There is no cap on the number of people sponsored in the UK for a company or for in total in UK as well. So at the moment, there is no limit in the number of people that can actually come to the UK using the skilled worker visa category. So all of these points, whatever we just talked about, right? We've covered it in the 4 videos. I'll give you the links to the videos in the description. And we also did a live Q&A session taking questions from all of the people about the skilled worker visa when it was going live. Now we'll see the detailed cost and some specific scenarios and the questions that people have been asking, especially for people who are trying to switch from inside the UK. Now, first of all, what is the cost for an employer? So when an employer decides that he wants to actually sponsor someone, they need to decide which company category that they form under from the Home Office definition. So if you have less than 50 people and less than 10 million pound turnover, or less than 5 million pounds in total assets, then you fall under the small company category. If you have more than 50 people or more than 10 million pounds turnover, then you fall under the medium and large company. So for a small company, the one-off fee for getting a sponsorship license is only 536 pounds. And then for every certificate that you want to apply, for every person that you want to sponsor, it's 200 pounds, 199 pounds per certificate. On top of that, for every year, you need to pay something called as an immigration skills charge, ISC. And this is about 364 pounds per year, which means in the 5 years that if you're going to sponsor an employee, then you'll end up paying 1,820 pounds. So apart from the one-off fee or sponsorship license, if you're a small company, less than 50 people, it costs you only 2,000 pounds. That's all it costs for you to get a sponsorship license and also sponsor somebody for the entire 5-year period. So considering the amount of money that people spend to hire someone, pay someone, the 2,000 pounds is basically the lowest amount that they have come up with to say that this is all you need from a company perspective to sponsor someone. If it's a medium company, obviously they made the sponsorship license cost and the immigration skills charge 3 times higher, but overall that comes to about 5,199 pounds if you want to sponsor someone for 5 years in total. So again, for a company that is doing more than 10 million pound turnover, this is again a drop in the ocean from their perspective. So the ISC, in fact, the immigration skills charge is exempted in some cases. For example, if you're sponsoring a tier 4 student, then you don't end up actually paying the ISC, which is the bulk of the cost, and all you will end up paying for that person is only the 200 pound certificate of sponsorship. So they're making it even more easier for sponsor to sponsor someone by reducing the cost of the ISC, by removing it for students and also for some scientists and some teaching professionals, because they want to encourage the sponsors to sponsor more of those people as well. So how long does it take? What's the process like, right? They've made it really simple. As long as you're a legitimate business, you can actually get all the documentation that they're asking for pretty easily. The Home Office says that it takes this is all what is written in the Home Office documentation, right? So it takes about 8 weeks for most of the employers is what they say. But they have also introduced a service called as a priority service, where if you pay 500 pounds and within 10 days, most of the employers are saying that they will be eligible for getting this priority service and getting a decision and sponsorship license. The Home Office may visit your business or your work location, make sure that you have a legitimate business, you're running a proper office, and you are actually hiring for a legitimate business, and you're not running just a body shopping service. So there is a sponsorship helpline with the Home Office that you can call, and if you're actually a sponsor, you can call them up. There is a helpline number where you can ask questions. If it's not still clear in your head, you can ask questions, especially during document submission. If you're unclear about some documents that they've asked for, you can call them up and ask them. So what does it mean for employees actually who is going to switch to it? So in a tier 2 ICT, your company will probably pay all your visa cost, and they'll probably try and help you with the application of the visa process. In the skilled worker visa category, once the sponsor gives you the certificate of sponsorship, it is the employee's responsibility to apply for the skilled worker visa. And it is then the employee's responsibility to pay the license fees, the visa fees as well. So in some categories, the employer might consider reimbursing you for this visa fees. That is dependent on the employer. That is an agreement between you and the employer. That is not what the Home Office would expect. The Home Office would expect that you pay this fees, but if you can prove that there is an agreement between you and the employer, that is fine. You can take money from the employer to pay for this sponsorship fees or to pay for this visa fees. But in normal scenarios, the employee is expected to pay for the visa cost. So when I came to UK, for example, I paid for my visa cost, all of it. So if you're inside UK, the visa fees is £704, and then you have to pay a NHS fees as well per year, £624. So for 3 years, so when you apply initially, generally people apply for 3 years. You could apply for lesser or higher, but I think most of the circumstances, they accept an application for 3 years. So this is the generic cost that I'm talking about for 3-year perspective. So if you apply for 3 years, so for the 3 years of the NHS, you need to pay upfront, which means that you're paying about £2,576 along with the visa fees and the 3-year NHS fees. So which means that for every person, if for every dependent, you are paying the £2,576. So if you and your wife are applying with no kids, then it's £5,000. With one kid, it becomes 7,700, and with a family of 4 with 2 kids, husband and wife and 2 kids, it's about £10,300. If your job happens to fall in the shortage occupancy list, which is published by the Home Office, there are some jobs that they've categorized as shortage occupancy list. Then they give you a small reduction in your visa fees, which then for 4 people, then it reduces to about £1,000 in total, because it's £250 lesser on the visa fees. But the NHS fees remains the same. And after 3 years, you can apply for an extension of 2 years, by which time after 5 years, you will get the eligibility to become indefinite leave to remain. So what does it mean for people coming from India? That's from within UK if you want to switch, right? From India, the visa cost is slightly lesser. So overall, it comes to about £400 lesser if you're a family of 4. So otherwise, the NHS fees all remains the same. And like I said, when I came to UK, I paid all of these visa costs, all of the extension costs, the ILR cost. I did not get any reimbursement from employer, or there was no employer agreement for these money. So all of it I had actually paid when I had come to UK about 12 or 13 years back. Now the employer, like I said, may decide to contribute, but that's a discussion as a perk, like how you could get a car allowance and other stuff. That's like a perk that you can agree between you and the employer when you agree on the sponsorship terms and conditions or the job terms and conditions. But in general, the visa cost is expected to be paid by the employee. So what is the intent of the skilled worker visa, right? So it is an option for legitimate employers when they have a legitimate need that they want to sponsor someone easily and hire someone easily who do not have an eligibility to work in UK without a sponsorship. It is not intended to be used as an excuse to just bring people to UK without a requirement. Like, you have absolutely no requirement, but you're just trying to bring somebody to UK. That's not the intent of the skilled worker visa. And if you try to use it, then that could be something that might land you in trouble with the Home Office. Especially if you're in India and an agency approaches you, the agency has no requirement as such. They don't have a work requirement, but they're trying to actually get money from you, and then trying to bring you into UK just because you want to come to UK and nothing else. Then that could land you in trouble. So be careful when an agency approaches you when they don't have a legitimate work requirement, but they are approaching you because they just have the capability to bring you to UK. So be very, very careful about these kind of agencies, because there's a lot of risk associated with it. Now let's look at, so from this point onwards, we'll be looking at all the people who are working inside UK. So we are not, in this video, we are not anymore covering people who are going to come from India. So we are going to be specifically talking about people who are already working in UK in an intercompany transfer in tier 2 ICT, where like if you work for an Indian company and that Indian IT company or whatever Indian company, right, they transfer you to UK in a intra-company transfer and you're tied to that company. And after 5 years, you have to go back. You don't get a indefinite leave to remain option today. So we are going to be talking about those people, what are the changes for them in terms of switching to this skilled worker visa and what are the advantages within UK switching perspective. So we're going to be talking about two main scenarios where previously, before the skilled worker visa came in, what were the two options for those people who are in tier 2 ICT. So generally what happens is the Indian consulting company organization B, they have a contract with the client organization A, and you are an employee of that particular Indian consulting organization. So many Indian IT companies practically all of the Indian IT companies do this. They bring you on a tier 2 ICT, which is intra-company transfer. You work for them, but because they have a contract with this client organization, you actually go and work for the client organization in the client organization's premises. And if you talk to your Indian consulting organization, if they had previously agreed to sponsor you a tier 2 general, you need to go back to India and have a 12-month cooling off period and also satisfy the resident labor market test, which means that your company needs to prove that apart from you, nobody else was able to do that job that you're doing, which is why they are actually bringing you or hiring you for that resident labor market test. They need to prove it. And then they can give you a tier 2 general after that, and then the contract still exists as it is for the client. From client's perspective, nothing has changed. You're still an employee of the org B, and they have absolutely no change in this process. They are continuing to give a contract and you're continuing to provide services for them. It is only between you and the Indian consulting organization the scenario has changed. The alternative is that the client agrees to sponsor you visa directly and hire you as a permanent employment directly. A lot of times this has happened. But the main problem that the client faces in this scenario is that you again need to go back 12 months, work in India for a 12-month cooling off period, also satisfy the resident labor market test to say that nobody in UK is able to do this job. I only want this person because they are the only person who can do this job. So that was a big deterrent. These two were actually big deterrents for a client, even if they wanted to sponsor someone or take you in a permanent employment, which again, a lot of people had done it, but there were big deterrents in terms of this process, how they wanted to sponsor it. Now the Indian consulting organization is nowhere in this picture. This also used to happen though, even though there were big deterrents in this process. Now, what has changed after December 2020 in the points-based system, right? You don't have any cooling off period and you don't have any resident labor market test, which means that you're free to go to your Indian consulting organization and say that, can you sponsor me the skilled worker visa? Because for you, the cost is literally nothing. Whatever you're spending in ICT, probably going to spend much lesser in the skilled worker visa. So the Indian consulting organization doesn't lose much, except for the fact that after 5 years, you might get an ILR and you might switch after the 5-year period. But if they agree, then you switch within the UK. The Indian consulting organization gives you the skilled worker visa, switches you from ICT to skilled worker visa. Again, from client's perspective, nothing has changed. You just moved from ICT to skilled worker visa. So no cooling off period, no resident labor market test, and the legitimate need is clearly evident because you're already providing services, you already have the knowledge. So the process is really, really simple in this case because you're actually getting your sponsorship changed from your intercompany sponsor, and they already know that how to get the sponsorship license because they've already got the tier 2 ICT sponsorship license. They just need to get a new license for the skilled worker visa category and a new certificate of sponsorship. Now, again, scenario 2 is also pretty easy right now. If the client wants to hire you directly, all of the deterrents are gone. There is no cooling off period. There is no resident labor market test. The cost of the skilled worker visa is very less. The process is very, very straightforward. So they made it ultra simple for the client organization to actually hire you now and give you a sponsorship license. And the legitimate need is also clearly established because you're already working for them. You're already providing services to them. So it makes sense, absolute sense for them to hire you directly. And even the cost is going to be lesser, right? Because, typically what happens is the Indian consulting organization will charge 3 times more money than the salary that they give you, 3 or 4 times more money than the salary that they give you. So the cost to the company, if they hire you directly for client organization A, is going to be like, 1/4 or 1/3 of what the cost that they were paying to the Indian consulting organization, which means that for them it makes a lot more sense to actually give you sponsorship and give you permanent employment. So there is also a scenario 3 where your Indian consulting organization doesn't agree to this process. Like I said, they are afraid that you might switch after 5 years, or they, as a policy, they don't do it. And also your client organization, they are willing to hire you, but they don't want to sponsor license because again they have a company policy against sponsoring license or sponsoring visa to anyone. But they're happy with you, and they don't care whether you come through an organization B or a different organization. They are happy to pay the same amount of money that they were paying to the previous consulting organization to another organization. But they won't pay more in most circumstances, and they are happy to switch the contract to somebody else as long as you can continue to come and provide the same services that you've been providing under the same terms and conditions. Now, in this circumstance, you can potentially switch to another consulting organization. Could be another Indian consulting organization, or could be another consulting organization within UK which has got a sponsorship license already and is willing to sponsor your licenses or sponsor your visa, as long as your client has agreed that I don't mind switching to another consulting organization if it benefits the employee and my cost remains the same. For them, the contract still remains the same, except that it's with a new consulting organization or with a new organization, basically. So it depends on the need of the client. So in this case, we are talking about the client has agreed and the new company is willing to sponsor and the old company was not willing to sponsor. So this allows you to switch to a new consulting organization C. Now, why would this happen, right? What is the point of this? The point is that your client might be unwilling to sponsor a visa. They might be really happy to get the contract for you or really happy to hire you, but for sponsorship process, they might need to involve the legal team or the senior leadership approval. For example, when I was working in a multinational organization, I was a IT director and I had 200 people in my organization, and I could have made contracting decisions for them, hiring or all of those decisions. But if I needed to sponsor visa for someone, that's a legal decision, or that's a legal team that I need to bring in, or probably get approval from a much senior level. But at my level, I can decide the budgets, I can decide the cost, and I can hire somebody that I want to hire, or I can change the contract to another organization. So that's all within the purview of a particular level of the organization. And they don't want to go much higher up to get the sponsorship approvals, because that could be a long process and that could get denied as well within the organization as a company policy. Which means that they're happy to provide you the contract as long as you can find a sponsor somewhere else. So that is where this process, the third scenario that I explained, comes in, which is also happening with a few of the organizations, few of the employees. They're able to find another sponsor as long as the client is happy. The main point here is the client, you have established a working relationship with the client, and they are willing to switch the contract to somebody else as long as you are going to come and do the work, the same work that you're doing, and the terms and conditions remains the same. Again, from the client's perspective, the cost of the company is same or probably even going to be lesser if they can agree for a slightly lower cost. And your work continues within the UK. From their perspective, nothing has changed, just the contract has changed. And you have years of work experience, knowledge, and skill sets for the job, and there's a legitimate need in terms of the skilled worker visa category. Again, this is all in my understanding, the Home Office rules of legitimate need and requirement is still here in this process. Now, after 5 years with the company C, you can apply for an ILR and switch to the client directly if he wants to hire you at that point, because at that point you don't need a sponsorship. So you don't need to work through a company C. You can directly go and work for the client if he is happy with you after the 5-year period, or can switch to any other company after the ILR. That's the advantage. Now, you cannot do contract roles in the skilled worker visa directly. You're not allowed to do contract roles. You will always be a permanent employee of the sponsor C. The contract is between the company C and the company A, pretty much like how any Indian IT organization will have an agreement or a contract or a statement of work with your client organization. It's pretty similar. They can have a company-to-company contract, but as an individual, you cannot do a contracting for an organization in the skilled worker visa category. And as such, the even if you're indefinite leave to remain, or if you're a British citizen, they are making it really difficult for contract roles in IT with the IR35, which I've explained in a separate video why you can't continue to do contracting in IT, especially in UK, because of the IR35 regulations that is coming in. So anyway, that's kind of both ruled out at that point. And your salary will be agreed with the company C, and could in theory be based on the contract that company C is able to get with the client, which could mean that because, like I said, originally the Indian company that has brought you takes almost 70-80% of the money, and they give you only about 20-25% of the value as salary. Now the new company could probably give you a much larger salary, so there could be again that benefit on top of the ILR as well, but that's all dependent on how you negotiate with the new company. And potentially there could be other perks that you can negotiate with the new company as well, and could be higher, and could also be more attractive in terms of benefits that the new company could potentially give you, because they could get the same amount, or they could get even if they get slightly higher amount, it's still giving them enough room for making sure that they can increase the salary at the point of time, because you are taking the contract to them, and which is again something that you can negotiate with the company. So it's mutually beneficial for both the parties at that point. Now, during the switch process, a lot of people had asked this question, and this is again only my understanding. You can start the visa processing with the new company, you can get a certificate of sponsorship, you can apply with the Home Office, and once you get the visa, that's when you inform your once you get your decision, that's when you inform your Indian consulting organization. And you can check this with the Home Office. If you have any doubts, you can actually call them up, understand what the process is in bit more detail. If you still have doubt, if you still want to clarify, you can call up the Home Office and confirm with them as well. And while this visa application is being processed, if your Indian IT company comes to know about it and they cancel your assignment or cancel your tier 2 ICT, per my understanding and per Home Office guidance, you can still continue to live in the UK because your work visa application is in process and progress by the Home Office. So as long as there is an active work visa that is being processed, under process, you've already submitted it and it's being processed by Home Office, during that point you can still continue to be inside the UK legitimately, and you can call the Home Office to confirm this scenario specifically, so that you don't end up with any exemption. Don't sit with an assumption. This is a guidance that I'm giving you. Call up the Home Office and confirm that you're able to do that. Do not just take this at face value at this point. I'm just giving you my interpretation of what the existing scenario is. But you cannot continue to do work without a work visa. You still need a work visa issued by the Home Office. Only after that you can go to your client and start working. You cannot work for the client during that intermediate period. Once the Indian IT company cancels your visa and cancels your assignment, you don't even have a contract with the client to continue providing services to them. So you can't work during that intermittent period if your IT company, Indian IT company, decides to cancel your work visa. Once your work visa is issued, once your skilled worker visa is issued, you definitely have to quit and inform your IT consulting company, because they need to cancel your certificate of sponsorship. And remember, the certificate of sponsorship is assigned to one person. So they can pretty much reuse this certificate of sponsorship that they have got allocated from the Home Office for somebody else. And it frees up the certificate of sponsorship for them to use to another person that they want to, if they want to. And the key points to check here is that you make sure that the company that you're getting, you're going and negotiating with, to give you the sponsorship license, and you're trying to connect your client with, make sure that they are a legitimate sponsor. Their name should appear in the registered list of sponsors that Home Office publish and update on a daily basis. That list I've already shared multiple times. I'll give you the link to that Home Office registered list of sponsors in my description as well. There are roughly about 33,000 sponsors in UK, and that list gets updated on a daily basis. You can look at the company name, and all of the company details are also there in the company beta house. Basically, you can go and find out. Make sure there is a website. Make sure that you contact the company through their legitimate email ID and not through Gmail or those kind of public domain emails. Make sure the company is really legitimate before you actually start this process. That is really important. So one scenario that I want to explain is that if you are trying to find this option of third scenario that I talked about, your client is willing to give you the contract with another organization, but then you are struggling to find a legitimate consulting organization. See, I've given you some tips to how to find it, but if you still need, if you're ending up in that scenario, very few people might probably end up in that scenario. But if you do end up in the scenario where you're still not able to find a legitimate consulting organization that is willing to give you a sponsorship license, as long as your client is okay with that, do let me know. I mean, send me an email and I'll try to try to see if I can help you with some more tips, specific tips in that particular scenario. You can email me ananti.lifestyle@gmail.com. I'll give you the email address in the description as well. But only if you end up in that scenario, and if your client, if you already discussed with the client, but if you're struggling to find a consulting organization which is willing to give you a sponsorship license in that scenario. Again, I just want to make sure that the disclaimer is there that I'm not an immigration advisor. I'm trying to make these videos and try to because when I came to UK, a lot of people had actually paid a lot of money to these immigration companies where all they were doing is basically providing the same clarity or the same interpretation of the rules, and they were making basically lakhs and lakhs of money or thousands of pounds. I don't want people to end up wasting their money unnecessarily when the information is really clear from the Home Office, just that you haven't found time to go through all the documentation and understand it. That's the intent of this videos. But make sure that you do your own decision based on your own research after you get clarity from this video that whatever content that I've provided. All of the information is from the Home Office documents that I've just read, and I've interpreted it, and I've basically given my understanding of it in this video. So hopefully this video was useful to you. Until next time, thank you, bye.